Every day in the USA, people find themselves in court.
All right, let's go on the record in the matter of the state of Michigan versus Marcellus King, 26693. And Sergeant Oborn, if you can please unmute.
All right, we should be all set, Your Honor.
All right, and Sergeant, your name for the record, please.
Sergeant Stephen Oborn.
All right, please raise your right hand. Do you solemnly swear or affirm the testimony that's given this matter be the truth, the whole truth, and nothing but the truth?
Yes, I do.
And you may proceed on the warrant.
On May 26, 2026, at about 23:45 hours, Officer Kyle Cox and Officer Stathakis were patrolling the area of northbound 4th Street and Vinewood as a double unit when they observed a white Chevy Tahoe with the Michigan registration plate of 2RAM15 traveling in front of them. The vehicle had a dark front window tint and items hanging from it, creating an obstructed view. Officer Stathakis conducted a lien inquiry of the vehicle, which revealed the vehicle's EIV equaled N. Lien also showed the vehicle's registered owner had a suspended driver's license and active warrants. Officer Cox activated their overhead emergency lights, initiated a traffic stop, and the vehicle stopped in the area of northbound 4th and Cedar. Officer Cox approached the vehicle and the driver, later identified himself as Marcellus King. King from within the vehicle indicated that the driver's window did not work, so Officer Cox opened the driver's door. King immediately stated, "I don't have nothing," and proceeded to nervously laugh. Officer Cox asked King for his driver's license, and he stated he did not have one. King also stated he was currently on probation. While speaking with King, Officer Cox detected a strong odor of alcoholic intoxicants emitting from King's person and observed his eyes to be glossy and bloodshot. Officer Cox asked King how much alcohol he had to drink tonight. He admitted to 1 beer. Officer Cox asked King when was the last time he was in trouble. He stated a year ago because of tickets. King then provided his identification card. While speaking with King, King stated several times, "Check it," referring to his vehicle. Officer Cox observed a cellophane bag tied off and a lottery ticket bindle in the driver's pocket door. Officer Cox asked King about these items and he claimed they were from weed. Officer Cox asked King for consent to search the vehicle and he provided consent. Officer Cox advised King to exit the vehicle and he immediately stopped talking, began displaying a panicked demeanor, and was reaching around his center console. Officer Cox advised King to leave his belongings and he stated he was looking for his lighter, despite the cigarette already being lit. Officer Stathakis and Cox observed King grab a lottery ticket bindle from the radio area and begin crushing it with his right hand. Officer Cox reached in to attempt to control King's right hand to stop the possible destruction of narcotics evidence. King immediately began resisting by turning away from Officer Cox, pulling his arms underneath himself and curling up his body. Officer Cox entered the vehicle and began attempting to gain control of King's arms while he continued to resist. Officer Stathakis deployed his department-issued taser to King's left arm. After a brief struggle, Officer Stathakis and Cox were able to secure King in the handcuffs. King was removed from the vehicle, searched, and secured in the rear of their patrol vehicle. The lottery ticket bindle from King's right hand revealed a cellophane tied off with a chalky white rock substance and a smaller paper bindle with a white powdery substance, which were suspected to be crack cocaine and powdered cocaine. While searching the vehicle, Officer Cox located a metal glass vial in the center console. The vial was labeled Fentanyl RX only and was nearly full with a clear liquid. Officer Stathakis located an open 24-ounce can of Ice House alcohol behind the passenger seat on the floorboard, which spilled. A lien inquiry of King showed his license to be suspended and have 5 prior violations. King was transported to Wyandotte Police Station, where he was searched, photographed, and later lodged into cell 12. During booking, Officer Cox asked King if he was willing to perform field sobriety tests, and he agreed. Officer Cox administered the horizontal gaze nystagmus test. During the test, King stopped following the stigmas with his eyes and kept moving his head, so the test was ended. Officer Cox read King his chemical test rights verbatim from the DI-177 form and asked him to take a breath test, which he said yes. Officer Safticus administered the breath test. The results of the two samples were 0.12 and 0.11 BAC. Officer Safticus tested the suspected cocaine substance using a Sergi Narc cocaine ID swipe, which tested positive. The suspected fentanyl liquid was not tested due to being clearly labeled. The crack cocaine weighed 0.56 grams and the powder form weighed 0.39 grams.
All right, thank you. Upon examination, complaining witness, I do find that the offenses charged were committed and there's probable cause to believe defendant committed those offenses. And counsel, your appearance, please.
Good morning, good afternoon, Richard T. Serrano, P33828. Your Honor, today I appear as MIDC counsel on behalf of which my client for arraignment purposes only. Sir, please state your name.
Marcellus King.
All right, and so counsel, as to the arraignment.
Your Honor, I have in the interview process, I have read over verbatim each and every count that's alleged against my client. Also, advising him of the maximum penalties involved, the nature of the case, and also of the additional enhancements regarding subsequent offenses, or in this case, habitual offender for notice. He understands them. I've explained to him his advice and rights, all his constitutional rights. He is asking for appointed counsel. And Your Honor, I'll address bond at the appropriate time.
All right, the court.
Formal reading standing.
All right, the court will waive the formal reading. Sir, you do have the right to have an attorney. If you're unable to afford an attorney, you may ask for one to be appointed to represent you. And in fact, you have had the opportunity to speak to an attorney today. Is that correct?
Yes.
The court is also signing the petition in order for appointed attorney for felony matters. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. Excuse me. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be against you in court. Do you understand those rights?
Yes.
The court's going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on June 4th. 8:45 a.m. Counsel as to bond.
Your Honor, as to bond, my client is 42 years old. He does have a ED diploma. He is currently enrolled in WC3 Culinary Arts Program. He's a first-year student there. He's doing well. He likes it. He hopes it leads to further secure employment. Right now, Your Honor, he lives with his significant others. Supports 2 minors, ages 4 and 15. Your Honor, the court has in front of it his criminal history. It is what it is. I will say, I asked my client if he ever failed to appear in court before. He said no. He's always appeared. He's always faced up to whatever is alleged and dealt with it. As you can see, Your Honor, he is here. He is presently promising to come into each and every court date. He tells me he has nothing pending. Is that correct, sir?
No.
Other than this? All right. Are you on probation or parole?
Yes.
We talked about probation. Tell the court what your probation is.
Out of 36th district. Out of 36th district.
And what kind of case are you on probation for in 36th district?
It was a gun case.
Okay. With that, Your Honor, we're leaving the court's discretion. My client wants me to ask for a personal bond. I said, well, that may be with some conditions if it's granted at all. We ask the court to consider a personal bond with a tether. Your Honor, the crimes, albeit resisting and or obstructing a police officer, can be many things. I don't think in this case, again, I read the report, but it does not appear to be any crime of violence. But I'll leave that in the court's discretion, Your Honor.
All right, sir. How long have you been on probation?
Probably like 6-7 months.
Okay. And so it's important to note that you had 7 counts in that matter, and one of which was assaulting, resisting, obstructing an officer, and habitual offender 4th offense notice. Both of those matters were dismissed. And you're on probation for felony firearm, or felony concealed weapon. Which,
Yeah, they didn't catch me with they didn't never catch me with no gun. I ended up just paying just to have to get out of jail. They never caught me.
sir, I'm not interested. I'm not interested in the facts of that case. You pled guilty.
Okay.
And somehow the habitual offender 4th offense was dismissed. So I'm not sure if the issue is authority or not, or if you have zero interest in obtaining treatment for what seems to be a drug issue that's lasted for about 21 years, sir, or not. But while counsel, your client may appear all the time, the court has, that's only one of the factors that this court must weigh determining bond. The court finds that your client is a significant danger to not only the community and not only himself, but also to law enforcement. And as such, the court's going to set bond accordingly. Sergeant, would you like to address bond?
Your Honor, just his criminal history speaks for itself. We got 2 felony counts here along with 3 misdemeanors. I'm asking a minimum of 50,000 with the tether.
Given that Mr. King is currently on probation for a felony, and now he is facing multiple felonies, habitual offender 4th offense notice, as well as operating while intoxicated is another charge, not even having a valid license, yet was still alleged to have been behind the wheel of a car. This court has significant concerns for the safety of the public. The court does find $50,000 10% bond is appropriate. In the event you post bond, sir, you're not to possess or consume any alcohol or drugs that are not prescribed. You're not to possess or have access to any firearms or weapons. You're not allowed to anyway, given your felony status. You are not to operate a motor vehicle. You're not to be released without a GPS and alcohol tether from the Wayne County Jail. Any questions?
What's that?
Have a good day.
Thank you, Your Honor.
Thank you. Are you ready on Ms. Simon?
Yes.
Are you already aware of what her bond violation is?
I
Let's
thought
go
it
off
was,
the record for a moment.
I thought it was getting a new case, sir.
No, I'm pretty sure a bond violation is that she violated her tether.
Oh, no,
Okay, I'm gonna head and go chat with Ms. Shaw.
I better go back.
Yes. All right, thank you. Let's go on the record we are on the record in the matter of the City of Wyandotte versus Evelyn Cook, 2663.
Your Honor, Richard P. Serrano, P. 3 trillion on behalf with my client presently in custody in Wayne County Jail. Ma'am, please state your name.
Evelyn Cook.
All right, thank you. Today is the date scheduled for the pretrial in this matter. Counsel?
You have to read with the prosecutor, Your Honor, that going to plead guilty to the amended charge, disturbing the peace, and what that entails. I believe he should be able to make a factual record, and if that is accepted, then the other charge, original charge, was sorely.
All right, ma'am, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
All right, and you heard the plea that was placed on the record, correct?
Correct.
As to the amended charge of disturbing the peace, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights.
Correct.
You understand as well the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Correct. Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea today?
No.
Any immigration issue?
No.
All right. And counsel, if you can please log in your client.
Ms. Cook, on or about May 15th, 2026, in the early morning, approximately 12:30 a.m., were you in the city of Wyandotte outside in a public place?
Yeah, I was walking, night walking.
Outside?
Yes.
Okay, there came a time where you had contact with the police. Is that correct?
When I came back from my walk, the police were at the end of a driveway next door. Yes.
Okay. And at that time, they had some complaints that there was loud noising in the neighborhood. Some of it was your raising your voice, yelling.
I was not raising my voice. I was being yelled at by the next door neighbor.
Okay. What? And you also raised your voice when the police officers were there.
Defended myself. Yes.
Ma'am, there's no defense to if you raise your voice, then you should raise your voice back. Were you
I was being yelled
disturbing?
at.
Listen to me, ma'am. Were you disturbing the peace in such that the police had to be called?
No, I was not.
There you go. What kind of trial would you like, ma'am? You told me that you at one time you
I'm
raised your
only
voice
disturbing the
point
peace. That's all I know, and that's what I'm sticking with. I was not yelling outside, but nobody. Somebody was there yelling at me. That's what
How
I'm
were you-
saying.
How were
I'm
you
not
disturbing
cuckoo.
the? Tell the court how were you disturbing the peace then?
I was defending myself against somebody that was yelling at me, the next door neighbor.
Ma'am, okay, counsel, let me interject you for a moment. Ma'am, did you enter a backyard that does not belong to you?
Yes, next door. So to drop off something that I was asked to drop off from the girls that were there partying, and I live next door. So I dropped it off and I left.
What's that? Beer?
Yes.
Okay, well, I don't hear a factual basis, counsel.
At one time, the police officer said that you cursed, used profane language, ma'am. Did you?
I did not use no profound language. No, I did not.
Okay.
What kind of trial do you want, ma'am?
Well, I'll let you go back into a breakout room with your client, counsel, and then
What I also did was yell at me for pretty much 10 minutes in the breakout room, but I'll go back.
ma'am,
Yes.
you may want to rethink your manner of speaking when you're speaking to your attorney.
I wasn't
You do
aware
not-
that he was my attorney.
Well, ma'am, who
He's-
did you think
He said he was
meeting
with the
you?
prosecutor. I don't
Again,
know.
you're interrupting me. I can see now why there seems to be an issue. Ma'am, let somebody speak before you're just interjecting with what you feel as though you need to say at that particular moment. Mr. Serrano is your attorney. I'm fairly certain he introduced himself as that, but I'm going to guess that you were too busy talking over him to hear him. So we're going to put you back in a breakout room. You're going to speak to him in a respectful manner, and then we'll see what the next steps are. We'll recall this matter.
Thank you, Your Honor.
Thank you. All right, let's go on the record. We're recalling the matter of Evelyn Cook, 2663.
Once again, Richard T. Serrano, P33828. I appear as I'm see counsel on behalf with my client, presently in Wayne County Jail. Ma'am, please state your name.
Evelyn Cook.
Okay, and so we're recalling this matter because we could not establish a factual basis previously. Counsel?
Your Honor, I would like to try again. If I could while you're my client, does the court need anything else before that?
No, just was the conversation more amenable this time?
Yes, it was more orderly.
Very good. Thank you. Okay, and you may proceed, counsel.
Thank you. Ms. Cook, on or about May 5th, 2026, approximately 12:30 a.m., were you in the city of Wyandotte?
Yes.
You ended up in a neighbor's yard when the police encountered you. Is that correct?
Yes.
Right. At that time, you said you were delivering a case of beer, but you told the police you were looking for your daughter. Which was it?
I was in the yard.
Okay. You won't gave you permission to be in the yard, is that correct?
I was looking for my daughter. She said she was over there, so I was looking for my daughter.
Had there come a time where you got loud in an outside area loud enough for neighbors to hear?
Yes.
I'm satisfied, Your Honor.
Yes. I can't hear.
Right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement. Counsel as to sentencing.
My client's been in custody continuously since this incident. That's 12 days. Even press time served. Your Honor, I believe that she is something out of character for her at that time. She thought she was doing the right thing. She is on probation in Lincoln Park. Probation officer is aware of that. So if the court will restrict time served and or fines and costs, you'll need time to pay those fines and costs. Are you working now, ma'am?
No. But I will make sure my fines and costs are paid for at an appropriate time.
But that you leave in the court's discretion, Your Honor.
Okay, well, ma'am, why are you on probation in Lincoln Park? What are you on probation for?
I'm on probation for a case that was brought downtown, and they put me on probation in Lincoln Park.
Okay, so your probation officer is in Lincoln Park, but what is the conviction that you are on probation for?
It was a drug case in Wyandotte.
Okay, right, that's out of this court.
Mhm.
All right, and ma'am,
Yes.
why do you think providing beer for individuals would be a good idea?
It wasn't a
No,
good
it was
idea.
not. I suggest if you want to stay out of jail, ma'am, these are the better choices. And so, ma'am, how do you support yourself and your daughter if you're not working?
I don't support my daughter. My daughter's got her own home.
Your daughter's what?
My daughter supports herself. She has a job. She works for a doctor's office. She went to college for medical.
Okay.
She just asked me. I was going to the store to get a vitamin water, which I had when I was arrested, and she asked me to give them something to drink.
Okay. So, ma'am, how do you support yourself if you're not working?
Well, I work for the state of Michigan, but I have to find my own patients. It's home health. I'm still employed to the state of Michigan. You just have to find your own patients in order to get a check. So right now,
so let me understand something. With a felony drug charge, you're still employed by the state of Michigan for home
I
health care?
I'm still employed to the state of Michigan, 20-something years, yes.
Well, that's interesting.
Yes, I am.
All right, the court's going to order 13 days jail credit for 13, $200 fine, $100 cost, crime victim assessment fee of $75, justice system assessment fee of $50, $325. You pay that within 60 days, ma'am?
Yes.
By July 31st.
Thank you.
Have a good day.
Have your
You too.